Number 39, People versus Derek Smith, 21105 FC.
Jessica Blanche, appearing on behalf of People.
Good afternoon, Your Honor. Marcia Craig on behalf of Mr. Derek Smith.
Mr. Smith, can you hear us?
Yeah.
All right. Today's the date and time set for two things. One is your attorney has filed a motion for what is called a Ginther hearing for ineffective assistance of counsel. I'm going to start with that, and then we are going to.
I already know you're going to deny that, so you can just get past that if you want to, because you biased. So go ahead and deny that. Get to what you got. Go ahead, go.
Okay, Ms. Kracher, I've had a chance to review your motion, and I've had a chance to review the people's response. I'm happy to hear any highlights from you if you wish. So what would you like to inform me of?
Sure, Your Honor. Again, I understand the court has reviewed the motions and the response. I'm just going to highlight a couple of things briefly, Your Honor. First of all, we'll start with the response from the people. The people represented that defense counsel negotiated a resolution to 11.5 years to 25 years. My client indicates that that was actually the first offer brought to him by Mr. Feaster. Moreover, the issue that my client wants to bring up is that he continuously made requests of defense counsel regarding evidence. We've already had discussions about the ladle. We've also had discussions about the two knives. I believe the ladle is very, very important to this case from the aspect that it would have been able to allow defense counsel to impeach the complaining witness at that time. Again, complaining witness at that time about her testimony. Also, when defense counsel and my client met, there was numerous conversations. My client explained that he insistently told defense counsel that he was innocent of this crime. And defense counsel, knowing that, continued on this path of not investigating the case. Specifically, there is no motion made to have any analysis done on the knives, the two knives that were located at the scene. I have couple of other points to make, Ryan. Give me just a moment, please. And also, it was going to other comments made by defense counsel relative to the coerciveness of, you're going to be convicted at trial. You are not going to be able to jury is not going to be able to get over the pictures. All of this is ineffective in coercing this defendant to make his plea. So I believe that we have met our burden by that if defense counsel would have investigated this crime, would have looked at all the evidence and put forth the initiative to make a defense strategy, that there would have been a probable outcome in this case. Therefore, Your Honor, I would ask the court to grant the motion. I know that the people have made comments about evidence and lack of evidence showing that that would have happened, as far as showing the probability of a different outcome. But that's what the Ginther hearing is for. That's what, the hearing to have to dive into it is. That's why I would request that we be allowed to have a Ginther hearing. Mr. Smith is potentially looking at a lot of time in prison. And I think justice demands that we provide him with all the opportunity to put forth a defense, which I defense counsel did not allow him to do by not investigating it. And also putting forth the defense of his innocence when defense counsel told him that he being the defendant, that he would be found guilty at trial. So with all of those factors, I believe that is what we are requesting today, Your Honor, that a Ginther hearing be allowed. Thank you.
Okay. Ms. Blanche, I did have a chance to review your response. I'm happy to hear any highlights from you today.
Just a couple, Your Honor. I think a lot of the allegations that were put in the motion are baseless, and there's not much evidence to support it, just based on Ms. Frazier saying that her client is saying this, but there's no evidence to support his claims. So in order to have a Ginther hearing, she has to show some evidence that there was ineffective assistance of counsel, which she has not done here. In fact, Mr. Bernstein filed 4 motions on behalf of his client. He filed a motion to quash, 2 motions involving excluding photographs, and a motion to exclude witness statements. He spoke to me numerous times on the phone about this case. So to say that he's just completely ineffective and he wasn't working for his client, I think is absolutely ridiculous, honestly, in this case, because he was. He filed probably more motions than most defense attorneys have filed in any other case. So I would ask you, plus everything I wrote in my motion, Your Honor, or my response, I would ask you to deny this motion.
Okay. Matters before the court on defendant's motion for a Ginther hearing. The test for determining whether a criminal defendant has been denied effective assistance of counsel. First, a defendant must show the defense counsel's performance was deficient, and second, the counsel's deficient performance prejudiced the defense. Counsel's performance is measured against an objective standard of reasonableness. To show prejudice, the defendant must show the existence of a reasonable probability that but for counsel's error, the result of the proceeding would have been different. Defendant says the following to support his position of innocence: that Ms. Crystal Lee made inconsistent statements about loss of consciousness. Second, that his relating to his defensive injuries and the fact that the police report stated 2 knives were found, but Ms. Lee stated that she was attacked with 1 knife. Defendant argues that defense's counsel's performance was deficient, and that second, defendant was prejudiced. The court agrees with the people. The defendant has levied baseless allegation after baseless allegation with 0 supporting evidence. Defendant was charged with 1, assault with intent to murder, 2, assault with intent to do great bodily harm, and 3, assault with a dangerous weapon. He pled no contest to counts 1 and 3 with a sentence agreement for 11.5 years to 25 years in MDOC. The court read the preliminary examination transcript not only in preparation for the motion to quash, but also in reviewing, I think, subsequent motions. That there were parts of that attached. Not only did Ms. Lee testify to what happened to her, so did her son, who was an eyewitness. The knife that was used to stab her repeatedly was recovered. The likelihood of a conviction in this matter was high. And let's not forget that the defendant was on parole at the time of the offense and was facing life in prison. So to say that Mr. Bernstein's performance was deficient and prejudicial, as the prosecutor has, as the defense attorney has stated, is simply, there's no basis for that. This defendant was facing potentially life in prison, and Mr. Bernstein negotiated a deal that was significantly less than that. So I don't understand how this was ineffective. We've discussed numerous times the question of the ladle, the question of the 2 knives, but we've also discussed in numerous court occasions, one significant being, well, the preliminary examination, which was not before myself, but the motion to quash, which was before me, where I reviewed that, and there's no question that Mr. Bernstein was effective. So there's no finding at this point. There's no evidentiary basis for the defendant's claim of innocence. Mr. Bernstein was not ineffective, and given the facts and circumstances of the case, I would find that he was actually quite effective. So the motion for the Ginther hearing is denied. We will proceed to sentence in this matter.
The defendant's gone off the screen.
Your Honor, he decided he wanted to go back in his cell. He totally got up and left.
Okay, so apparently this is a thing. So what I'm going to ask you to do is set up a monitor outside of his cell, and we're going to proceed to sentence him. I'll give you about 10 minutes if we could do that. We've done that in the last couple of weeks. So should be familiar territory. So we're going to set that monitor up and we're going to proceed to sentence. Okay?
He's actually out on his out time and then Mr. Smith, come on out.
I mean, hell, I don't care if we adjourn it. I mean,
Honestly, at this point, I told defense counsel this because I knew this was going to happen. He is failing to appear for sentencing, which at this point, he has to understand that I can withdraw my sentencing agreement with him and we can move the sentencing and judge at that point, you don't have to abide by the 11 and a half sentencing agreement years. And I've already told the defense attorney to let him know that he's supposed to be here for sentencing. The victim's here today. She wants to make an impact statement. And for defendants just to get up and walk out of the courtroom or walk off Zoom and not have to listen to the victim impact statement and not have to be present for sentencing, that's an absolute dishonor to this court, Your Honor. And I'm frankly sick of it. And at this point, if he's not going to abide by sentencing, he's not going to be here today, I'm going to withdraw my sentencing agreement. I'm going to ask you to move to sentence him according to his guidelines.
So he is on his out time right now and he refuses to come to the door. Like he's out in the day area. I don't know. I don't know if you can.
hold that thought. Hold on.
Well, first of all, before we have any discussion on this, okay, we haven't asked him if he's waived his constitutional presence to be here at sentencing.
Yes. If he's walked out, he's walked.
No, in the courtroom. He has a constitutional right to be here in the courtroom.
Right.
And he has not.
Date and time set for sentencing.
Well, let me explain.
Okay.
Okay. He has a right to be in this courtroom. That's my first response to that. Okay. So the court can order him to be here in person. Okay. And before we go any further with down this road, I think that justice requires that we bring him here.
Well, as you know, Ms. Kracher, justice may require that, but there's not really the justice to force that. So he was fully aware that today was the date and time set for his sentencing in this matter. Is he here today? Every other defendant that I ever sentenced, they wish to be here, we bring them here.
And he had that option, Judge, and that wasn't, the court wasn't notified that he wanted to be in person.
He hasn't put on the record that he waived that right, Your Honor.
He doesn't have to do that, Marcia. You had filed, you talked to him about whether or not he wanted to be here in person for sentencing, and he didn't want to be here in person.
I believe that a waiver of that is required, Ms. Blanche, okay? And that's up to the judge's discretion. I would ask for an adjournment of this matter. At least we bring him out and lay out what is before him.
We're not going to, quote, bring him out, Ms. Kracher.
I mean, what I mean to say is at least the monitor, that's what I mean. Before we go any further.
I'm going to give you a chance to speak with him right now. So I'm going to let them offer you the opportunity to have a conference with him right now.
That's all I ask.
Okay. I'll be back. And
where would I go to do that, Your Honor? Right here? Is there somewhere else?
In the hallway, conference. I mean, number one, he has to agree to it. So we're going to ask transport or we're going to ask the jail staff to let him know that I am telling him he has an opportunity to consult with you right now. Otherwise, we're going to proceed.
Okay. Can the jail staff hear? I'm sorry.
Yeah. I can hear you. Let me go ahead and see if he wants to come out and talk to you.
I don't know how to do the conference.
We're going to either do it in the hallway or in a conference room on your phone. They'll set.
Right. I understand that. I just don't know the logistics of what device I'm going to contact him with.
Oh, can you get on Zoom?
Yeah, I can get on Zoom on my phone.
Okay. I'm going to give you 10 minutes to figure out what you can. And
okay. I asked for them to tell him. There he is. Mr. Smith?
You guys just let me know what's going on.
Mr. Smith?
So I have him right now. He wants to speak with you.
Yes.
Can you hear me?
Mr. Smith?
Yes.
There's a development here that I need to talk to you about, sir. Very, very important. I asked that. Okay, listen.
Oh, sorry.
If you
need to be aware. Hold on, Mr. Smith, just please let me talk. You need to be aware that we need to have a conference really fast, and I believe it's going to be done via Zoom. Okay? You and I need to talk right now.
Yeah, about what?
Mr. Smith,
Huh?
the court is full of people. Trust me, I've worked very hard for
No,
you.
I can't
Trust
handle
me.
it. Hold on,
Okay.
Mr. Eckman. Hold on 1 second.
Yeah. Okay, I don't know how we're gonna do this, but I need to talk to you. Okay?
What now?
I can't do this in open court, Mr.
Can't do what?
She muted himself, so she's gonna do like a court thing with her. So you have to hold on here, just put that.
I can't even hear her.
She's muted right now. They're gonna take her out and she's telling you to hold on 1 second, okay? And I'm gonna exit out when she takes you out there, okay?
Yeah. I'm trying to hear none of this motherfucker got to say to me.
Gotta get sentenced, so you're gonna be sitting here dead time instead of making it all the whole time.
What it is.
Yeah, but why would you do that?
It's just what it is. Bullshit. What it is. What's she waiting on?
She's trying to get a breakout room.
Okay, because I'm not.
So the judge is not in the way and then other attorneys are trying to.
Derek, can you hear me? All right. Can you hear me okay?
Yeah.
All right. So here's what's going on.
What?
Okay.
Yeah.
Listen to what I'm going to say. Okay.
Miss
Listen very,
Fraser.
listen very carefully.
Huh?
Listen.
Court is back in session.
Thank you. Please be seated.
Back on the record in People versus Derek Smith, 21105 FC.
Okay. I'm going to ask a series of questions. Smith, Ms. Kracher is going to be able to answer most of those questions for you. You will have a chance to speak with me prior to my imposing the sentence. Ms. Kracher has asked, I should let the record reflect, conference in chambers. Ms. Kracher requested an opportunity to just address the court, other preliminary or secondary matters, either preliminary to the sentence or secondary to the prior motion hearing. I've agreed to let her make another brief statement. So go ahead, Ms. Kracher.
Your Honor, what my client would want me to reiterate and clarify and go over again is reference to the Ginther hearing. I'll make, what my client would like me to indicate relative to the ladle, that it was important in a sequence of events. Miss Lee, in the police report, indicated she was hit numerous times, okay, and lost consciousness from being hit with the ladle. Then at preliminary exam transcript, I don't believe she testified that she lost consciousness. And also, when you look at the medical reports, it also indicates she doesn't lose consciousness. This ladle is imperative to my client's defense from the aspect that it plays in the sequence of events in this matter. It indicates that possibilities of impeachment and the evidence, I believe, would lead to my client's being found not guilty. Further, the defendant's son testified he also used the ladle to hit my client. Therefore, how could the ladle be touched by two people? And what we were trying to put forth is previous defense counsel's inability to secure the ladle and to secure any kind of DNA testing deprived my client of a defense. Regarding the two knives, my client would like me to indicate, well, back to the ladle, that prior defense counsel never proceeded to secure the ladle or have them tested. Regarding the two knives, there is conflicting testimony of when the knives came into play. There's conflicting testimony that the knives were in the kitchen. There's conflicting testimony that there was only one knife saw, but the issue with the knives, what's important to remember is prior defense counsel never secured those two knives to have any kind of test or DNA on it. Therefore, you don't know who touched the knife, whose blood was on the knife, and therefore my client believes that that evidence was crucial to his defense and therefore deprived him of putting on a full defense, and therefore that would be the basis of saying that previous defense counsel's performance was deficient, Your Honor.
Okay.
I believe I've covered what my client wanted me to say.
Now, can I interrupt, please? Sorry. One thing you covered. How can, in the police report, she gave a brief detail, a description.
Mr. Smith,
How she was
Mr.
hit.
Smith,
How can you give a description of how you were hit if you're unconscious? How do you give a
There you go.
That's
Okay.
Let me take it from here, Mr. Smith.
Yeah.
His position is this, Your Honor. How can you recount any event of how you were hit or who hit you if you were unconscious? That is his position,
Yeah, she gave a
Your Honor.
description. She gave a full description. Then on the witness stand, she said she didn't remember.
this is not your opportunity to litigate this case.
And I just want to reiterate one final thought.
If you believe, I'm going to get it on the record.
When you look at the statements in the police report from the defendant's son's statement, Miss Lee's statement, and then you travel to the preliminary examination, okay?
It's a lie.
There are inconsistencies, specifically where the knives were placed, where the knives were grabbed, specifically regarding the ladle, who grabbed the ladle, who hit the ladle, who hit whom. There's inconsistencies between the police report and preliminary exam and the time of events of how this crime allegedly took place. So therefore, Your Honor, for those reasons, I believe this was a triable case and that defense counsel was made aware that Mr. Smith he expressed he was innocent and that prior defense counsel used his coercion in order to go forward with his plea. And I think that shows a reasonable performance below the guidelines, Your Honor. Thank you.
So as we look to reiterate, the court is well aware of the contents of the preliminary examination. As I've said, I read it both. I mean, obviously the district judge read it and bound it over for felony proceedings. So there was the live testimony that the district court found was reasonable grounds to bind this over. I've had a chance to review the preliminary examination transcript twice, once in relation to the motion to quash and once to the plea of no contest. So to some extent, this court is well aware of the contents of the statement. So, Mr. Smith, I have to jump ahead to something here.
Master police report with the statement she said on the stand. Did you read that? It only takes a preponderance of evidence to bond me over. All somebody got to do is
Mr. Smith.
So come on, man.
Smith, I just need to make you aware of something. I'm sure Ms. Kracher has advised you of this, but one of the things that you pled no contest to, or what you pled no contest to, yielded a sentence agreement of 11.5 to 25 years in the Michigan Department of Corrections. I need you to understand that one of the charges that you pled no contest to is assault with intent to commit murder, which has a maximum penalty of life in prison. So if the prosecutor withdraws her plea agreement, or her sentence agreement, that's on the table. You've pled no contest to that crime, not once, but actually twice, because we were in the midst of a plea and then you had some thoughts and then you came back and we did it again. So I'm just letting you know that it is possible what I told you that day, it's possible that you would have pled no contest to a crime, and if I don't allow you to withdraw your plea, you could be sentenced to the maximum. You need to understand that.
I understood it. Why would I take a plea like that if I understood it? A plea to life, and I can go to trial, and I could have just went to trial. That doesn't even make sense. I mean, come on. Why would I take a plea that somehow I didn't understand that? I would have never took that. I would have took a chance of going to trial if I'm going to get life.
What are your thoughts at this point?
I mean, at this point, can we just move the sentencing and hopefully he stops talking at that point and stop? Because obviously any misconduct Mr. Smith makes from the time he pleads the sentencing, I can withdraw a sentencing agreement. And also if he fails to appear at sponsored sentencing, I can withdraw my plea agreement. So we're moving to sentencing now. The victim's going to make an victim impact statement whenever the court allows her to, and we're ready to proceed.
I would like to put on the record, Mr. Smith, you have heard what Ms. Blanche said, and you've heard what the judge said.
What about the PSI? You didn't say nothing about the PSI, about the statements in the PSI either. About the
Okay, so let me start with you, Ms. Kracher. Are there any additions, corrections, or deletions to the informational part of the pre-sentence report?
Yes, Your Honor, if I can give my PSI.
Okay.
One of the charges I pleaded to, I can give life. And I would take a plea like that. They so foul.
Okay. To the face page, Your Honor, it says retained, I should be appointed.
Okay.
Moving on to the page 3 of the agent's description of offense.
Okay.
Paragraph 5.
Okay.
Okay. My client would like to add that a preliminary examination, Darren testified that he did not see defendant stab his mother. But the purpose of that, Your Honor, is to bring out the contradictions once at the parole board and when he goes to MDOC, that there is a contradiction in the preliminary exam and the police report, which I believe the agent is using the police report for the recap. I'm sorry? There you go, I was just getting to it. Page 71.
No, I did not stab her face. The glass that my son shattered and broke.
Mr. Smith, do not speak again until I ask you to.
Give me an attempt.
And 73, line 23. And this is not my contact with your mom at that time, no.
All we're asking is for that to be added into the PSI, the agent's description of the offense.
So page 71 and 72, what's the other reference?
Page 73, line 23 through 24.
Right. But page 73, line 4 says, I see him with the knife in his hand in a swinging motion. That was his response to a question.
Right, but it said that.
Judge, he can provide the preliminary exam transcript at his parole hearing if that's an issue, but this is going off the agent's description of
Right.
or the description of offense according to the police report. It says that on here, agent's description of the offense. So he can provide that.
I agree. I'm trying to sort of, there's a contradiction, and
Sure.
I'm not seeing a clear contradiction. So
Well, if I can, when he got there,
I'm not going to add to this.
Okay.
I am literally, if there was a clear contradiction, then I would make a note of that. So grabbed a knife. He does say start stabbing Crystal, moving his arm up and down. He did testify in the preliminary exam transcript that he did not get stabbed. So that is something that Mr. Smith, I presume, is going to appeal this. So he will have an opportunity to raise this issue on appeal. But I'm not sentencing him based on the agent's description of the offense.
Okay.
Oh, okay.
What's going
Next.
to be in my PSI?
Anything else?
yes. Page 4,
Go up and file.
paragraph 1.
Okay.
Excuse me just one second, Your Honor, I want to get the right. Again, my client would like to add the following. The victim testified at preliminary examination. She lost consciousness and did not see a knife at this point in time in the kitchen.
Okay. So where are you saying he just wants to add this at the end?
Yeah, at the end of the sentence.
Which sentence?
I'm sorry. Where it says victim's right form, the call for service after that sentence.
Yeah, what? I'm not understanding. Marshall.
And so again, so let me ask you, is there contradictory testimony in the preliminary examination, or is this another instance where, again, the client's not prejudiced in the sense that he will be able to utilize both the preliminary exam transcript as well as the police report in any appeal? But I just want to be clear that I'm probably not going to just add to this. So this is the agent's version of this.
Sure.
So
And I understand, and so it says on page 45, line 21.
Oh, Judge, there is a whole part that says defendant's description of the offense. He absolutely made no statement. He declined to provide a statement regarding the within offense. That was his opportunity to write down everything he disagreed on, what he didn't like about the agent's description, his own description of the offense, and he failed to do that. So we're not going to change the agent's description of offense to satisfy what the defendant wants when he had the opportunity to do it himself.
Well, Your Honor, if I may respond, the reason for no contest plea is civil liability. That's why you don't make a statement during those issues.
Then why does he get the opportunity now in the agent's description of the offense instead
That's what
of
I'm
his own
saying.
description?
well, I mean, as I've said, I'm not going to make changes that are not substantive description of offense. So
Yeah.
I'm okay. I'm going to leave it at that. Okay.
All right, yes, under consecutive sentencing, he would like after it says defendant was on parole, defendant was not aware that consecutive sentencing was mandatory with his parole.
So I could not speak to what the defendant was aware of. So I don't know.
Okay.
So I can't make that change.
Marshall, just forget it.
And then paragraph 3
Of what?
of page 4. My client indicates that this is taken off a phone conversation. Okay. They attempted to contact him by phone. My client cites MCL 791-270C. That requires conditions to be met in order for this to be used, which is a note telling the inmates that your calls are being monitored. The Washington County Jail is a correctional facility, and my client indicates that there was no such sign posted when he made this call.
Saying that at the jail, there was no sign posted at the phone station that these were being monitored or recorded?
That's
No,
what my
still
client,
not. It's still not.
I mean,
On every call, it says that before they even start the call. We can probably pull up the call right now.
But it's also
It's-
supposed to be a
it's not-
sign. It's also supposed to be a sign.
okay.
You know the law.
I'm not gonna I'm not adding, I mean, that's not before me as far as a challenge. I'm not gonna just add that.
Man, y'all
Okay.
so foul and corrupt, it don't
All
make sense. Everybody gotta see a judge, though.
And so moving on to the
We all gotta see.
criminal justice,
Yeah.
the juvenile history he disputes.
What do you mean?
He doesn't believe that's attributed to him.
We all gotta see Yahweh. Believe that.
Do you approve of that, Martha?
I got this I got this yesterday. I just met with him
Okay.
yesterday and today.
That I have no frame of reference. My assumption is that our criminal records are accurate. So I'm going to say it's probably, unless you have something that shows me it's not, I'm going to determine that our research and probation's preparing is accurate.
And then the adulterers were 1 of 15, the same argument.
All 15 of those are not
1 of 15, no, 1 of 15.
simply 1 of 15.
Yes, correct.
Okay. I mean, that's from 1992. I don't know whether that's accurate or not. Okay. Anything else?
And finally, Your Honor,
There's no signs posted by the phones, still right now.
Or we're literally at
Along with the recording, there's supposed to be signs posted by the phone as well under that MCR rule. Along with the recording, not just the recording, the saying the phone is being monitored. It has to be a sign as well next to the phones. So let's get that clear. While y'all
he is
Right.
the
Ms. Kracher, what's your next change proposed?
my next change is that as far as at the end of the agent's description, my client, a new paragraph added.
Not going to add any there.
Okay.
All the
All right. My client would, as we proceed at this point,
Blanche, do you have any additions, deletions to the informational part?
You all gotta see a judge one day. His name is God. Believe that.
I don't have any corrections to the report. I do have guidelines for it, but I know you'll get to that.
Well, that's next. Okay.
You all gotta
Let's
see.
take a look at that.
God. Believe that. All these lies and corruption. What you gonna tell God when you see him? Judge Collins? What you gonna
Okay, so here's what's going to happen. Do you have access to your victim right now?
I'm not trying to hear
No.
nothing you got to say.
And we're going to adjourn this 1 week. I'm withdrawing any report of your sentence. So we will be sentenced next week. For the record, Ms. Kracher and Mr. Smith, you have the right to be here in person, and if you wish to make that request, by all means, make it. If you do not arrange to be here in person, I will ask the jail staff to set up a monitor outside of your cell, and we will proceed to sentence with or without your participation. At this point, I am withdrawing all of my support and willingness to be compliant with the sentence agreement in this matter, and I will be sentencing you however I am allowed to do so under the law.
Okay.
So at this point, that is what's going to happen.
can I make,
No. And at this point, I'm going to offer the victim, who can hear me, an opportunity to make a statement. Or
Well,
wait,
I might as well, you gonna do that, I might as well go. Bye. I'm not hearing that.
okay. Might as. So I just want to give you an opportunity to ask her, or me to ask her, however we want to ask her.
Just the fix that is just texted her.
Okay.
may we approach
And I'm
briefly?
assuming, just so it's on the record, you're withdrawing my sentencing because he's been in contempt of the court and he's been contemptful to the court.
Yes.
Your Honor, just so the record reflects, I'm not available next week. I have a exam up in Alpena, so I'm unavailable next week. That's how I was going to approach him.
Okay. We can do it in 2 weeks. Not going anywhere.
Your Honor, are you all set with us?
That?
Are you all set with us in here?
this, but I just, from the jail's perspective, we're going to terminate.
She said she'll make it now. Her name's Crystal Lee. She should be on Zoom.
At this point, is Mr. Smith still present or no?
No, he took off and went back into his
Okay.
area, being out, I guess.
Okay, so you can sign off. We're going to go ahead and take our victim impact statement at this time. He's chosen to not participate in the sentencing at this time. So I'm going to go ahead and hear from her. She may or may not be willing to come back in 2 weeks, but we're going to make it as convenient as possible.
Okay, thank you. Sorry.
That's okay.
Okay.
All right, Ms. Lee, can you hear us?
Yes, sir.
All right, are you Crystal Lee?
I am.
I thank you for coming today. I want to give you an opportunity to not make this more difficult or more inconvenient for you. So if you wish to make your statement today, you may do so. You need to understand that Mr. Derek Smith has left the hearing, so there's no possibility of him hearing you. What's going to happen when we reschedule this in 2 weeks is that we are going to set up a computer monitor outside of his cell, and he will hear, if he chooses to listen, what your statement would be. But I don't want, you've now been sitting here all afternoon waiting. I don't want to make you come back again in 2 weeks just to have more kind of shenanigans unfold. And so what I'm offering you is, if you want to make your statement to me right now, I am all ears and I will listen to you. If you would like to come back in 2 weeks and make that statement to me, as well as on some level to Mr. Smith, you may do so. And I just didn't want to do anything without asking you what your preference would be first.
So that I'm clear, I can do the statement now and then do it again in 2 weeks when he can hear it outside of his space.
Well, not both. I mean, so what I'm saying is that if you don't want to come back here in 2 weeks, or you just want to be silent in 2 weeks and not participate in what has evolved into kind of chaotic proceedings on more than one occasion, I'm going to allow you to make your statement in peace to me right now, and I will listen to you without interruption, but we won't make the statement again. In 2 weeks' time, if you choose to make your statement, you're going to make your statement to me on Zoom. Mr. Smith will hear it as much as he chooses to hear it, and then you will have made your statement to both of us. I didn't want to take that right or that possibility away from you on my own decision. So I wanted to ask you what your preference would be.
I'll do it now. I'm fine.
What's that?
I can do it now.
Okay. So, Ms. Lee, I am absolutely all ears for you to tell me whatever you'd like to tell me right now.
Okay. Well, good afternoon, Your Honor. And I'm first and foremost, let me just thank you for this opportunity to address the court in regards to the life-altering event that occurred, not just to myself, but also to my son. I share with Mr. Smith. On December 1st, 2020, Derek made a conscious decision to brutally attack me from behind. I was hit so hard that I lost my Bluetooth that was in my right ear. After the first initial blow, I screamed with all that I had in me for my then 16-year-old son. My son made it to me from the upstairs of our home, and I am forever heartbroken by the details of the events described by my son, Darian. Darian discovered me in the middle of the kitchen floor, unconscious, with Mr. Smith, who was 6'2" and well over 250 pounds, hovering over me, pounding me. My son was able to get me awake long enough to shove me in the corner of the living room against the curio cabinet. My baby was able to do all of this for me, but not before his own father shoved him violently across the kitchen floor. My baby fought with every breath in his young body to save his mommy. His mommy's life, no child should ever have to go through that kind of distress. As I stood with my back against the wall, my son in front of me and Derek behind. It was sorry, 1 second. This is hard.
Okay.
It was in this instance of Derek's blows to attack me. I discovered that Derek had a knife. A mother's worst fear. Now my child is in harm's way. A complete maniac. I screamed I then went into mama cub mode and stretched my arms as wide as I could to protect my baby. I remember in that instant, my son said to Derek, "So you gonna kill my mom in front of me?" Derek replied, "Yup, this bee gonna die today." Unselfishly, and 16 years old, my son said, "You're gonna have to kill me first." That didn't make Derek stop. He had no regards for his own son being in harm's way and willing to give his life for the very woman that gave him his. Sorry.
Okay.
Now, I could be wrong, but as no mother should have to endure any of these thoughts or feelings that, needless to say, I was supposed to die that day, but I'm still here. I got some scars, but I'm still alive. Your Honor, this has not been an easy road. I fell into a very deep depression, but that's normal after being stabbed over 30 plus times, right? I watched everything I worked hard for slowly dissolve because I couldn't care of full business in Washington County. I was so, and overall, the PTSD has changed my life forever. Sleep, what's that? I'm often afraid to go to sleep in fear of the disassociation. My physicians don't even want me drive anymore in fear where I am. Countless of amounts of antipsychotic medications. I now have to take a pill to go to sleep, a pill to wake up, and let's not forget about the pill. I'm completely antisocial and have developed a social phobia because of the scar that Derek left on my face. It's about 4 to 5 inches on the right side of my face. I struggle daily with how I look now, thanks to a coward. So he took my life still in a sense. I'm breathing, but fact is, I haven't been living since December 1st, 2020. My son struggles and lives with the feeling of that he failed me as a son. He feels horrible for what he would describe as not being strong enough to keep his dad from creating scars on me that I now live with daily. When the fact of the matter is, he was and remained my superhero. Darian struggles with PTSD, night terrors, anger, and anxiety. That has resulted in continuous antipsychotic medication, 9 to be exact. He can't fall asleep without them. Darian has an extreme case of separation anxiety. Now, if I could address the coward clown of the hour, we know we're not here, but it's going to be on record, so whatever. I know wholeheartedly the point of this cowardly ambush was the whole, if I can't have you, nobody can. Well, I survived. You wanted to permanently mark my face in hopes that no one would ever want me. Well, how'd that work out for you? My Bible tells me in Isaiah 54:17 that no weapon formed against me shall prosper. And my Bible also tells me in Psalms 23:5 that my God will prepare a table before me in the presence of my enemies. So I don't need to forgive Derek. I need to continue to work on forgiving Crystal. I forgive me for thinking for a chance that you found God, that you found growth, and that you found parenthood. I forgive myself. Nothing less than a coward to raise your hand to a woman yet again. But today, release my forgiveness to me. Today, I release any negative thought that I won't be anything but amazing and beautiful. So with all that being said, you left the sky, but I am blessed and will continue to walk in the overflow of blessings, of being able to touch thousands of lives of countless women to walk away to save their life. So remember this, Derek, I am not that scar, but what I am is mislead to you. Thank you, Your Honor.
Thank you, ma'am. I can't tell you how brave it sounds to me for you to make those statements, and I thank you for sharing them with me. You are obviously free to come back in 2 weeks when we do the actual sentencing. If you don't choose to do so, that's okay as well. But I just want to make that available to you so you know that, and we will then proceed. So we are going to adjourn this 2 weeks. So Ms. Crater, I won't make you miss your preliminary exam. If in fact your client wishes to be here in person, I need you to arrange that. I'm not going to do anything further to support that. But if he wishes to, he's welcome to be here. If in fact there's any outbursts in the courtroom, we will do the same thing, take him to lock up and set up a monitor there. But that's what will happen in the jail as well. The only thing I might ask of the two of you is that there are guideline challenges, if you could maybe submit those to me before the hearing so I can have a chance to look at them, so we're not sort of like fresh doing that. So if we could do that.
Sure.
And then, again, you know, at this point, I will ask for your, we'll resolve the guideline issues. I'll ask for your comment on the proposed, well, there is no longer a proposed sentence, so I'm just going to ask for your recommendation. Ms. Crater, I will certainly hear from you as far as your comment on proposed sentence, and then allocution, and then obviously if your client wishes to make a statement that is to the court as it relates to his sentencing, I'm certainly going to listen to that, but I'm not going to, you can advise him, I'm not going to listen to his theories on litigating his case or his comments on my personality any longer. So that's kind of where we're going with that. So we'll be back here on the 17th at 1.